Good morning, everybody. This is Anthony Tharp regarding the issues that are going on in Jamaica as it relates to property I own, or I'm part owner, and I am the developer of the property. We had permits approved from 2008, and there was a delay because a company or US financial corporation, Capital One, filed a petition, a claim in the Supreme Court of Jamaica that they had an interest in our property. In 2012, June of 2012, the appeals court ruled that they didn't, and said their claim was to be dismissed. Unfortunately, that attorneys we hired chose not to follow our instructions and asked the court to dismiss it. And when Justice Brooks of the appeals court made that statement, our attorney jumped up on her feet and asked the court to dismiss it. The judge said it was too late then. They had already done their written judgment. So unfortunately for that act on the part of our attorney, the judge said it had to be sent back to the Supreme Court to be dismissed, and it must be dismissed. So the only thing that should have happened when that thing went back to the Supreme Court was for any judge that it went in front of was to dismiss it. We pretty much figured out was it. We filed the necessary papers to get it dismissed, and when we did have a hearing, we were told that John Graham had come on board. The attorney that was on board for Capital One originally was Mr. Holin, and I think Veronica Morrison from Holin and Morrison. And I remember the judge specifically asking Miss Morris, why did I bring this claim? Because the party that filed this would had no connection to the claim. Anthony Tharp and the other defendants didn't owe anybody any money, and they had no interest and no standing to have brought the claim. They have no interest in the contracts. And Mrs. Morrison, I remember holding down her head, flipping through papers and saying to the court, open court with a whole bunch of witnesses in there, that, my lord, that's the problem I'm having with the claim. I don't see any connection. Alright, so even the attorney that was representing this particular part, Capital One, admitted to the court that they didn't have any claim or connection, or she couldn't see it, but yet they brought it. So the judge asked her why she brought it. And essentially the judge was saying pretty much, and I'm paraphrasing, you shouldn't have brought this claim. Something is wrong with what you did here. But in any case, the judge sent it to the Supreme Court, remanded it to the Supreme Court. When it went down, as I said before, John Graham got on board with Capital One and filed an injunction. So when we went to the hearing to get it dismissed, my attorney, I had an attorney at the time, Mr. What's his name now? Johnson is an attorney, Johnson from Mobile. It wasn't Charles Johnson at the time. And Mr. Johnson went in there, and the judge started to disparage, I guess me, because she said to the attorney, don't you know you shouldn't bring anything like this or take any instructions like that from a client? Of course, that is as illegal as you can get. No judge is supposed to tell an attorney that he's not supposed to take instructions from his client. In any case, she said there was an injunction, and she was going to allow the injunction to continue. And even though I pressed Mr. Johnson to get the claim dismissed, the judge said she wasn't going to do it. This was Justice Mangatal, who I think now is practicing in the Cayman Islands. So Justice Man, and my thing was, if the appeals court had definitively ruled that these people have no claim, it shouldn't have been brought, why would be a judge now granting an injunction? She didn't grant the injunction, apparently. Justice V. Harris was granting an injunction, or allowing the injunction to continue without Graham apparently asking. I don't know if he asked behind or before we got there, but she said, oh, you have an injunction, right? Yes, that was his response. And Well, I'm going to continue it. She adjourned the matter. And after that, we had another hearing. The files kept disappearing, until finally Justice McCullough, which was the Chief Justice at the time, and you could interview Justice McCullough as well, because Justice McCullough should be quite familiar with this matter before it was dismissed. That I wrote to Justice McCullough and said enough is enough. I mean, the appeals court said this thing must be dismissed, and we are being dragged through the court, and the matter is costing us money. Our projects are being delayed. We have permits, and people are waiting on us, and we need an answer, a final answer from the court. So Justice McCullough appointed Justice Beswick, Mrs. Lawrence Beswick, and she gave a judgment in May 29th, on May 29th, 2015. Now, prior to that, Capital One had gone again and had an application in front of a Justice B. Morrison, appointing an administrator for an estate that doesn't exist. Ironically, anybody who looked at this, including the judge, should have known this was as illegal an act as you could get. Justice Morrison appointed a Lauren Gallagher here in Jamaica as administrator for a New York State estate. Now, trust, and put in there, she's been appointed as trustee. First thing in the law, a Jamaica judge cannot appoint any trustee for a New York State domicile trust. The trust has no interest in Jamaica, no property, anything. So I don't even know why they were appointing her, because the court had already ruled that the trust has no interest or legal right in our property. So nonetheless, he went and he appointed her as administrator / trustee for a U.S. trust, which Jamaica has no law or jurisdiction allowing a local judge to appoint anybody anywhere outside Jamaica. So, of course, the obvious shock of that happening was there, but the purpose for doing that was they were trying now to say, the appeals court hadn't dismissed it, so the appeals court was giving them the opportunity to correct whatever deficiencies they had, which is nonsense, because the court is not there to aid anybody to correct any deficiency. It's not going to delay, or supposed to delay, other people's judgment to allow somebody to file and correct a mistake, and there was no mistake. So anyway, they appointed this Lauren Gallagher, who works for Capital One, as administrator / trustee, and with the intent that could now allow them to continue. But when Justice Beswick came and made her ruling, she considered all of that and said the fact is it has no bearing on anything. You'd still and dismiss the claim. All right. So I wanted to go through all of that to let you know that I am pressing persons who look at this and have the opportunity or ability to make a difference and get the word out, to understand that this is a claim that has already been won. We won this claim from the time the appeals court made a ruling, and we got a final dismissal of the claim officially on the 29th of May 2015. And at that point, John Graham, who's representing Capital, jumped up and said, well, he doesn't understand what the judge means when it's dismissed. I mean, it's written on the judgment. I don't know if you could see it, but it's written on the judgment. Okay, I'm just showing you to know I have all the documentation, and it's in the court's record, so nothing is being made up. And Justice Lawrence Beswick says these parties have been engulfed in litigation for several years. The issues have engaged the minds of almost 12 judges of the Supreme Court, and the appeals court. So here Justice Beswick is saying the matter has engulfed at least 12 judges from both the appeals court and the Supreme Court. So in short, when she made her decision, this was no light decision to say, the judge is making a mistake in the ruling. And as a result of that, when John Graham said he didn't understand the judge saying, because here it is, striking out the claim. So the judge said she was going to do a clarification, which was done on the 23rd of December 2015. Now in our documentation we have the 23rd, 24th, because on the 23rd of December Justice Beswick was supposed to show up in court and she didn't. I guess she was on vacation, but we showed up and we contacted Justice McCullough and said this is nuts. We can't stand any more delays. Justice McCullough called her and told her she should come down and deliver her judgment or fix the situation, because I guess Justice McCullough was herself fed up because we were pressuring her that this is nonsense and it should stop. So she came down on the 24th. So this is titled the 23rd, but it was the 24th that she gave the thing. And I'm just going to go through a couple of things to make you sure this is matter has been ruled on and resolved in terms of us, and we were successful, and yet we can't get the judge to, or the court, not even the judge, the registrar of the court to set or give us a final order, which we are due according to the law. So even though the case was dismissed and we went to assessment of damages, where the court appointed 2 expert witnesses and calculated that we were entitled to damages, or we were owed a specific amount of damages at a preliminary level. It wasn't a total calculation, and they submitted that, and it was incorporated and filed in the official records of the court that the expert witnesses appointed by the very Supreme Court went in and found that we were owed substantial damages. And from that took place, and a date was set for a final hearing, a hearing on the matter, so we could appoint some forensic auditing firm to complete the calculations and get a final order so we could enforce the judgment. At first, John Graham went in and, without us knowing or notifying us that there was an application made, he asked the court to decide whether we're entitled to damages or not. And so Justice Batts, who himself had witnessed not witnesses, but appointed the expert witnesses, suspended or abandoned the date that was set for damages. So, which was unusual again, but he did it. And I'm not, based on the interaction I've had with this judge, I don't think he had any ill intentions. We weren't present and represented. In fact, when we found out that was what happening, it was like the morning of or the day before, so I'd ask a representative to show up in court, but there was little he could do. So in any event, John Graham got him to suspend or postpone the date that was set for assessment of damages. And so the matter came up in front of a Miss Justice C. MacDonald, and this is the order from Justice C. MacDonald. And Justice C. MacDonald pretty much and John Graham and Stephanie Graham were present at that hearing, his daughter. The case managed conference is adjourned to 16 May 2018 for the court to determine 2 preliminary issues: whether Mr. Tharp can properly pursue or defend any claim in a representative capacity or otherwise, whether the inquiry for damages should be heard in 2 separate hearings so as to determine the issue raised in paragraph 7 of the Honorable Justice Batts' order of the 27th January 2017. And the issue that was raised by Mr. Graham, it was that whether we're entitled to damages or not, and whether I could represent the company, my company, or represent myself as far as the question was concerned as it relates to the damages. He also, at the hearing, which was set for the 25th for 16th of May 2018, he raised in that hearing as to whether a court order from the US was applicable in the matters in Jamaica. And so when it came up in front of Justice G. Brown, and this is the order of Justice G. Brown. Justice G. Brown again ruled in our favor, rejecting everything Mr. Graham was trying to do. And even though some of the decisions of the judge is not written, in terms of the rules of the court, as long as the judge makes a decision and the parties are present, everybody is bound by it. So the judge told him we were entitled to the damages based on an undertaking for payment of damages that Capital One had given to the Supreme Court, and that undertaking must be honored. He understood that what the application was trying to do in terms of asking whether I could represent Business Ventures and Solutions, and even myself. The judge said he understood what was being done, and the move was to try to get the company to be unrepresented by removing me, and therefore then Graham could simply say, oh, they have no representation, and apply for default judgment against the company. But I don't know how he could get default judgment, because there was no claim in front of the court. It was already dismissed, and all that was in front of the court was for the court to give us a final order on our damages. So in short, we just went to collect our money, nothing else, and have accountants come in and sort out the money. And the court said, well, this is what the accountants found, because the accountants had to be used because the undertaking and the order from Justice Beswick both stated clearly that the party, the judgment creditors, which was us, had to prove the damages. So that's why I went and got the court to approve the accounting firms or the accountants to come in and do the assessment, because I didn't want them to say I came up with numbers. So because of an objective stipulation in it, not even the judge could technically come in and say, oh, you owed $10, because the undertaking said we had to prove it, and Justice Beswick said we had to prove it. And Justice G. Brown essentially said he understood what these guys were doing, trying to get us out of the picture so then they could come up with some strategy to say, well, we didn't file anything for the damages. And he said it was not going to happen. He wasn't going to make it happen. The damages have to be paid because they gave an undertaking, it had to be honored. And also he was officially recognizing me as the representative, even though the court rules allowed me to represent. I think rule 22.4C 1C or something to the effect. He went ahead and stipulated that in the order. And so he stipulated in the order the assessment of damages in the matter is scheduled for the 29th and 30th of January 2019. So in the 29th of January, the 28th, Miss Alexis Robinson showed up from Mass Fetcher and Gordon, apparently, filed a document in the court that the damages for Business Ventures, that was the company, was withdrawn. She couldn't withdraw damages for me or my other joint venture partners because we are separate parties. And she withdrew damages for Business Ventures and Solutions. I remember this is January 2019. Justice Beswick ruled that I was representing the company, and there was no appeal, nobody came in, there was no other order rescinding that order, so the only person that could file such a withdrawal would be me. So she came in, and that was fraud, obviously, and filed that withdrawal. So on the 28th, the evening before the hearing, she filed the paper. So when we showed up in court on the 29th, the judge, Justice D. Morrison, who had also now appointed Lauren Gala trustee for a US-based trust, which he has no authorization or jurisdiction to do, showed up laughing that, oh, he doesn't have to hear anything on damages because the damages were withdrawn for Business Ventures. So I said to the judge, well, even if Business Ventures damages were withdrawn, then there were other parties here. He said he didn't want to hear anything from us. So he abandoned the hearing and didn't even adjourn it to another date. So from then, we have been filing papers after papers with the registrar, and the registrar is responsible for setting the dates, to get our dates reset, because he didn't adjourn it, which the court is supposed to do, and he just left it in the air pretty much. So we are out there in space. So technically, we're still in court. Technically, we're still in court at that hearing because it wasn't adjourned. So the case management conference is adjourned to 4th July 2018 at 2 p.m. for 2 hours. And why Justice G. Brown adjourned it to the 4th of July was because we had filed for interim payments and remedies, because when damages are substantial under the rules of the court, we are entitled to receive interim payments and have the court implement other orders that will ensure that we do get an opportunity to go collect our money or the judgment. So he set it for 4th of July. When we went to the 4th of July hearing, Justice Henry Mackenzie heard the matter, and files didn't show up. As usual, files were disappearing. Files didn't show up. And when the files didn't show up, she said she noticed there was an application to substitute the partners or the successors in interest of Business Ventures and Solutions in place of Business Ventures, because Business Ventures interests had been transferred. So technically, even at the 29 January hearing, when she withdrew the damages for Business Ventures legally and technically wasn't entitled to withdraw anything because they weren't owed any damages, because damages were transferred to the other partners. So she said she wanted to substitute the persons because before that January hearing, but she didn't have the files, so she adjourned it to November 25th. That was the first time we saw Alexis Robinson, and she showed up in front of Justice K. Anderson, and we told Justice Anderson we don't know this woman. We didn't ask her, invite her, retain her or anything. He said, well, he's going to allow her to stay and observe, which again is questionable, but said. So technically she was withdrawing damages for a company that didn't have any interest or right in the damages, because those rights and interests were sold and transferred from August of 2017. So Justice G. Brown had already considered all those factors, including some suggestion from John Graham that a U.S. court had issued order that I couldn't represent Business Ventures because they had sold my interest in the company in October of 2017. Now, what's key to that is they sold it in October of 2017, so they allege, and some fraudulent transaction. And that was just the interest I supposedly had in Business Ventures at that point. But remember, Business Ventures was already sold from August of 2017 and all its interest transferred. So technically and legally, I didn't have any interest in Business Ventures anyway. So they didn't buy Business Ventures and Solutions. They said they bought my interest, and I didn't have any interest in Business Ventures and Solutions. So what they claimed they bought paid my estate for $55,000 US, which went into the trustee's pocket. My trustee's pocket was $55,000 for zero interest in anything. But Justice G. Brown had considered all of that when he made this ruling. And he ruled Mr. Anthony Thorpe is permitted to represent the defendant's company in these proceedings. So in short, May 16, 2018, almost a full year after the August sale of Business Ventures and Solutions and the alleged October 2017 purchase of all my interests, which they are now claiming that gave them ownership of Business Ventures and Solutions. But even if it did, as I said, Business Ventures didn't have any interest or wasn't owed anything. Justice Lee Brown considered all of that and ruled and threw it out and reset the matter for hearing in January. Saying all of that because I want you to be confident that this matter has been decided, been ruled on, and several judges have made their decisions regarding the matter, and yet from 2019 until now, we're being set up in a scheme to defraud us of our damages and money. But what's significant to that, and why we're pressing the issue as well, is that it's not affecting just us. The development that we're doing was the largest real estate development on the island at the time. It had franchise locations in Clarendon, Mandeville, St. Mary, Westmoreland, and it would have generated anywhere from 500,000 permanent high-paying jobs to as much as 1 million in the secondary market. Of course, the development on Queen's Drive alone, which is the property they've been trying to defraud us of, relying on the actions of judges who ignore the rulings and the dismissed claim, would be $6.7 billion, a $6.7 billion investment in the Jamaican economy on that site alone. Which means when judges and attorneys engage in fraud, and they might be getting petty cash from a company that's abroad that has no interest in anything, only swindling money or trying to swindle people, they are not only affecting us, they are affecting my partners, they are affecting the entire island of Jamaica. Now that $6.7 billion investment just on Queen's Drive alone would have prevented Jamaica from even going to anybody and borrowing any money. I remember the Chinese company that was engaged to construct the project, when I think Bruce Golding went to China for some meeting, or his finance minister, what was his name again? Anyway, they were in China, and the company that was retained, a Chinese company, financed the project, or was providing most of the funding. The broker there actually called me and said, "What is your prime minister over here doing, begging for money? And we're sending, or we've approved constructing and spending that kind of money in Jamaica." So I told him, well, we couldn't explain that, but we are a private entity, and we were one of the first companies, or amongst the first companies, I think, anywhere that was able to get government of China approved financing through their development bank via a construction company that they had an interest in. So this was no game or or activity that was not beneficial to the entire country. But when people like John Graham and those other attorneys who are engaged in corruption and underhanded behavior, they affect the entire country. And so we need responsible persons to really deal with that, because it's not only us. Can you imagine what they're doing to other people? And when you tabulate and all of that, the massive amount of damages that Jamaica is having, because these people keep committing these crimes, and it's a crime. Now we have a major concern, and I called the fraud squad in Montego Bay a couple of days ago, and I said to the fraud squad, I got word because I got some medical issues and ended up in the hospital, right? So I had to contact the Supreme Court and let them know I couldn't make it via Zoom to certain meetings because I was pretty much in the hospital. So immediately after that, I got word that the Miles Fletcher and Garden had sent trucks down from Kingston with wires in there to fence our property and to run the people off that we gave authorization to be on the property. So I called the police at Area 1. They said, well, the fraud squad has to handle it because we identified the fraud. And I remember I was saying to the lady, she's saying, oh, this matter is in court. I said, no, it's not. I said, furthermore, we already got the rulings from the court, and what's in the court is separate from the matter that was already judged. What's in court is us trying to collect our money from that first hearing, but the matter has already been judged and the court ruled in our favor, and I've been in possession and ownership of the property since I've been in possession of the property in 2006. And Justice G. Brown, as a matter of fact, in that same hearing of May 16, when John Graham asked him about possession of the property because of this foreign court claiming about my interest, Justice Brown said, even if I didn't have an agreement or a contract that stated otherwise, because of the Constitution, what is called the Limitations Act, which colloquially is referred to as the squatters' rights. Because I was in possession of the property for way more than 12 years, nobody could dispossess me of the property. So here, after all of that and the rulings from the court, which are settled matters, my Fletcher and Garden last week sent people down onto the property, and I hear they're down there fencing. So I called the cops, because I heard I was in the hospital. I figured, I guess I was dying or dead. But they figured if I'm gone, they're going to snatch the property and my partners are going to be left hanging, because I'm the only one that they visibly see. And that's all right. But when I called the cops at area, when I spoke to a DSP lady, and she was saying to me, oh, my representatives are there, but there's nothing. She looked at the court papers that they brought, but because it's in court, she can't do anything. And I said, I don't remember what her name. I won't call her name anyway. I said, how are you going to say something like that? You're telling me these people are committing fraud outside the court with fraudulent papers, and you can't do anything. So I said, you can only do something if I come down there with rock, stone, and hire a truck and people go up and start lick people off of my property. That's when you're going to show up, right? She said, no, that's not what she's saying. So then she referred us to the fraud squad at Summit. And I said, well, they're familiar because I filed complaints with them years ago, and I was there a couple months ago, a couple years ago, when these same people attempted to sell my property, and I gave you all the evidence, and yet nothing is being done. In fact, the cop that I spoke to at the time, the detective, said, yeah man, let them sell it, because when they sell it, we can lock you. I said, we're not going to play that game because we have stuff to do. The fraud is there, and there's a law that's called the Law Reform Fraudulent Transaction Act, and I cited it to her, and I said, all they have to do is come down and say the property is theirs and it's not, and it's fraud, and you're supposed to lock them up under the law. So she sent me down there, spoke to the lady at Summit, and she's saying, oh, she remembered the case because the police, the fraud squad in Kingston, had said they wanted assistance to interview Hullin and they couldn't find him. They invited him and he wouldn't show up. And I said to her, like I said to them then, Mr. Hullin on Market Street, I see him every day when I'm there going to court. What do you mean you can't find him? So there's a lot going on that needs to be resolved, because allowing these things to happen are undermining and destroying the country. And a lot of my partners are worried because of the enormity of the corruption and the fraud. But like I said to them, our greatest protection is to expose it, because as long as it's covered up under some bush, if any nefarious activity is taken out against us, nobody's going to know what's happening, and that's been my greatest protection. I've filed the documents with the U.S. courts, with the U.S. law enforcement, FBI, Controller of Currency, Securities and Exchange Commission. I filed it with JDF. I filed it with the Integrity Commission. Everybody. And so they know. And when I send letters to the Registrar, to Chief Justice Sykes, I put an open letter and I tell them I filed this with law enforcement all over. And that's how I've managed to survive all of this, because at one point they went as far as trying to get a U.S. judge who signed some corrupt court order about they buying my interest to say I couldn't represent or attend court in Jamaica, and if I did, when I landed back in the U.S., they would have U.S. Marshals detain me indefinitely until I admitted to it. Of course, I showed up the very day they said that they wanted me there with my Jamaican passport, and I lifted it up to the judge and said, I am a Jamaican. I travel and have a Jamaican passport. You have no jurisdiction to tell me I can't go to court in Jamaica in a matter where somebody is trying to steal my property and have me as a defendant. Capital One people over there jumping up and down. Oh, Your Honor, you're saying you don't have any jurisdiction. I say you don't. And we left it at, I wrote a complaint to the Chief Judge of Florida for that court and said, your judges are intimidating me or trying to threaten me, which is an illegal act. That was the last time I heard anything from them, because I wasn't doing anything illegal. I filed what is called a Chapter 7 petition, and that's simply me saying I wanted the state to come in and audit my account and see what debts I owe, and if I owe any debts, then to settle it. I didn't owe anybody any money, that's why I filed it. I filed it to stop Capital One and John Graham from doing what they're doing. So they try to spin it now to come in and use that as a backdoor to say I owed them money and therefore they were going to buy my interest, pay me $55,000 to settle the whole thing. So I won't go on because I know time is of essence. So in short, this matter has been judged, and it's the corruption and the fraud that's going on both in and out of the court that we need addressed. Now, one detective had asked me to file for the court to give them orders to investigate the fraud in the court. Justice Sykes, which went in front of, he wasn't the Chief Justice then, said he wasn't going to grant it because the police don't need any order from any court to investigate fraud inside or outside the court. So, of course, the police still haven't done anything. So there's a lot going on, but the important thing to remember is that I'm saying to you, if you take up the mantle and decide to assist us in getting the word out, it can only help everybody on the island of Jamaica because we help to clean the system. It will help us to also ensure that developments that are slated for the island can go forward. So it's much bigger than just me being in court. It's a whole lot more, and whatever documentations you need, we have. They're authenticated, they're in the public records in the court, so you can access them yourself. Nothing is being said to you that cannot be proven. Alright, so I want to thank you. I don't want to take up too much of your time. But headline in the press would be like, corruption destroys the Jamaican economy. Alright, so this is a massive issue, and we welcome any aid and we appreciate the assistance. All right, thank you very much, and have a great Sunday and all of that.